Okay. What we're going to do today is go through the changes that I talked about last month that were effective, of course, September 1st. And the big thing is that I'm sorry, I'm going to have to let somebody in, I think. I apologize. The big thing is all the contract changes that were required by law. So we'll go through those as well. The other thing is we're going to go through the public improvement district. Can everybody see the screen?
Yes.
Okay, because I've lost y'all, and normally I have you on the side, so I know that y'all are there. But we'll go through the new public improvement district, and then the HOA law changes and how it affects individuals that are in a mandatory property owners association or an HOA. And then I'm going to go through the addendum for mandatory membership in a property owners association, and then a few other updates. Now, what I am going to do is I had a request to go through one more time the addendum concerning right to terminate due to the lender's appraisal. Okay. And everybody can see the form, correct?
Yes, we can.
Yes.
Okay, great. Okay. So why was this form created? The form was created because too many license holders were accused of practicing law without a license, which is a crime. They were adding all sorts of language regarding the ability to terminate based on the appraisal. So TREC provided a document. This document can never be used for FHA or VA. Why? Now I'm going to show you why. Everybody see the third-party financing addendum? What you need to look at for FHA and VA purchasers, not only are they protected, it says notwithstanding any other provision of this contract. So nothing you would have written or added will have any bearing on this. This was directly related to protecting those purchasers that are FHA purchasers and VA purchasers. The other thing that is to help these purchasers, if the property doesn't meet the appraisal value, which is the fill in the blank there, that's usually the sales price, obviously, the 3-day notice that's required in paragraph 2B does not apply to any VA purchase. So again, that's why you can never use this form with FHA or VA financing. There are 3 options on this form. The first one is a total waiver. If your buyer does not have written authorization from the lender that they can write a blank check and make up any difference, buyers cannot mark this box. It has to be from the lender in writing, and it has to be literally that the buyers will still be individually approved, even if it doesn't appraise for $50,000 more than what the property's sales price. Paragraph 2 has to be from the lender as well, but this is a partial waiver. And 2 things have to exist in order for the buyer to waive the right to terminate under the contract, under this provision, okay? And what are they waiving? They are waiving that 2B in third party, property approval. They'll waive it if the property approval is not obtained because the opinion of value in the appraisal does not satisfy lender's underwriting requirements. Okay, so the lender would have to say it does not satisfy our underwriting requirements, and the opinion of value is X or more. So what happens here, the lender will say they can make up a $5,000 gap, or they can make up a $2,500 gap. So if the property was 100,000 and the lender says they can make up 2,500, right? They could only put in 197.5 or more because the lender has capped it what they're able to make up the difference in writing only. Again, buyers don't get to use 1 or 2 unless the lender has given written instructions and given this value that's going to be in 2-2. The last one is not a waiver. It's an additional right that a buyer would have to terminate property approval. Property approval in 2B is for the lender. If the lender doesn't decline the property, the buyer can't unless the buyer has this provision marked on this addendum. Two things have to happen. Number one, they have to have it, they have to give notice of termination within so many days after the effective date of the contract. And it says if the appraised value according to the appraisal obtained by buyer's lender is less than X number of dollars. So if it's less than that, and the buyer has to deliver a copy of the appraisal to the seller. We've had lots of buyers use this provision and they don't have the appraisal. So they cannot use the provision anymore because you have to do two things. The lender is, the appraised value came in less than this value, and the buyer has to give a copy of the appraisal to prove that to the seller. Any questions?
Hi, Marilyn. Good
Hi.
morning. Yes, so when you say that we need written lender approval for items number 1 and 2, as a listing agent, do I ask the buyer's representative to provide that, or do I go to the buyer's lender directly?
Well, I'm going to tell you, the buyer is probably not going to give the buyer agent a permission to share any communications between the borrower and their lender. That's a fiduciary duty that they have, so they won't do that. If you go directly to the lender, most likely they will not respond at all. We've had lots of lenders who will not respond to the listing agent. It is a huge risk for a buyer agent if they don't handle this perfectly. We've had lots of them mark the total waiver. Okay, I'm sorry, I've got to let people in. Sorry about that. Okay. So again, it's going to be difficult, as I said, for a listing agent to have a seller have pretty good assurance that the buyer can use that provision, right?
Right.
We've had too many lenders who will not respond to the listing agent, and we've had sellers who did not go forward with that offer because they didn't have assurances from the lender that this blank check could be used. Buyer's agent are at high risk if they don't use these two provisions for their buyer perfectly. Poor sellers, they're still at risk. I'm going to tell you, I probably had a dozen where a buyer wanted that property, right? They marked one. And then when the appraisal came in and they had to make up the gap, right? They didn't do it. They defaulted. I don't know about you, but if I were a buyer agent and I had knowledge that the buyer didn't have the ability to do that, that buyer has not only violated the code of ethics, they probably committed fraud in purposely defrauding the seller. We have to treat all parties fairly in every transaction, even if we don't represent them. And for a buyer agent to know the buyer doesn't have the ability to make up any difference, woo, very serious. Does that help?
Thank you, yes, Marilyn, thank you.
You're welcome. So again, as I said, when buyers want to use this form because the seller may have said, I want you to totally waive it, they can't just do it. Somebody who knows their financial ability to make up any gap in the appraised value and sales price, they're the only ones that can make that call. And it must be in writing, because we've had too many where the agent was told something verbally by the lender, and then the lender said, no, I never did that. You know what I'm saying? Nothing happens in a transaction unless it's in writing. And okay, that's not to me, right, Kayla? That's just a note to everybody else. Yeah.
Correct.
Okay. All right. So again, that's one time that if you don't have all your T's crossed and your I's dotted, it could come back on you. As I said, we've had over a dozen where they did the waiver, the total waiver, and buyer couldn't make up the difference, or buyer then decided, oh, I'm going to negotiate with the seller, right? So they came back to the seller with an amendment to reduce it or meet them halfway. And the seller said, no, I'll see you at closing. And if you don't close, I'm going to see you with my attorney. So you see, once they threaten something like that, these are promulgated forms, and it's pretty clear what it says. When it says waiver, it means I don't care what it appraises for. I will pay you the sales price. Big problem if you don't do that. Okay, any other questions? If you do, just take yourself off of mute and ask me. All right. So now we're going to get back to the topics that we're going to do. And the first one is the contract changes. You're going to see here, I'm going to have to let somebody in. You're going to see all of the contract forms that changed, along with the new addendum for public improvement districts. I'll call it the PID addendum, okay? And then the disclosure relationship with a residential service company. The current one has a date that is 11/8/2021. In fact, I'm going to share you that for the first time ever, forms that we are using have a date that hasn't occurred yet. Okay. And so, again, listing agents, if you receive an offer, make sure that the date is 11/8/2021. Okay. And it's in the top right-hand corner. We've had a lot of agents, unfortunately, didn't pay attention to all the notices about the contract forms changing, including commercial forms changed. And so because of that, we had a lot of situations where they've had to contact me because it is a violation to use a repealed form. Okay, what do I mean by that? It means that you're not able as a license holder to ever be given the ability not to use the current form. And this situation occurred, and the reason it has the date 11/8/2021, as I told you before, is that there was an emergency provision to approve the changes because the law went into effect September 1st. Normally, TREC has a traditional methodology and approach. They have to. They're required by law to do it. They post the proposed changes. They engage in discussion regarding that. Then TREC will meet again and either make changes to it. Then the TREC Broker Laureate Committee meets, and then the final TREC meeting will be on November 8th this year. Now, they could change the form. This would have been an emergency provision form that we were using. They could change it. So we might have new forms again. So again, just be prepared as listing agents and buyer's agents. You better use the current form on all of these. Okay, that's what is required to do. So what changed? Well, the law changed that paragraph 6E7 says now if the property is in a public improvement district, seller must give buyer written notice as required by the property code. An addendum containing the required notice shall be attached to this contract. So the buyer has to sign this addendum and then attach it to the offer prior to the seller agreeing to it and executing the contract. Okay. It is treated the exact same way that 6E3 is, the statutory tax districts. They changed the law that says there'll be big punishment for sellers if they fail to provide the special district notices like the MUD notices or a levy improvement district notice or a water control improvement district. All these different statutory requirements, if the seller fails to provide them prior to the offer and have the buyer sign them, the seller is subject to penalty. So what does that mean? It means that it's now a law. The public improvement district is treated the same way that our MUDs are treated. Okay. Now the next one, paragraph 7H, which is our residential service company. So that paragraph changed because the residential service companies are no longer licensed by TREC. They were for years, and then the law changed. They're now licensed by the Texas Department of Licensing and Regulation. So again, these are the two changes, and they were the changes that reflected what the law changed. Okay. Now on paragraph 22, we have a change because the addendum, all addendum are attached to the contract in paragraph 22, including the temporary leases. And this addendum has right above other, it says addendum containing notice of obligation to pay public improvement district assessment. Okay. So again, these are the changes that are reflected in the form. It affected the commercial property contracts, improved and unimproved, and all of the contract changes for every contract that TREC has. And again, it's very careful that you make sure you don't have some template that you've created and you're using, instead of making sure you have the correct forms for all the changes.
Marilyn, I have a question.
Mm-hmm.
How do we know if a property's in a PID?
I'm going to get to that next.
Okay, thank
Okay.
you.
All righty. Okay, so here you go. Sometimes I'm just going to tell you, as agents, we are required to, the seller turns to us and says, do I have this, or is this a part of my property? And you're going, really? You're the one who's lived in it, and you're the one who's paid in taxes, and you're asking me? Well, the source that you go to is, of course, the appraisal district. And you'll look under the tax jurisdiction. The problem is if you are the one giving this source of information to the seller, you better use the notice of information from other sources. Otherwise, you're going to be into trouble. Okay. But it is, again, this addendum is required to do it. There's a key that you look at for sharing this. Okay. And this is the addendum that they provided, this new addendum. It doesn't have anything about values, but it does have names, and it does say where was it, how was it formed? Was it formed under a municipality, a city, or was it formed under the county? Now I'm going to tell you that you have got lots of special districts. They're called special districts, all of them are, okay? And for instance, this is one of special districts in Harris County, I think I chose, yeah, Harris County. Notice how they have MUDs, utility districts, WICKEDs. And sometimes they have language that would make you look and say, huh, I wonder if that wording is a special district that was formed as a public improvement district. All you have to do is go to the website for that district. All these districts have websites, and you would look and see if it was formed under Chapter 372. Most of them, you're going to find that they're not. They're very, these public improvement districts happen all the time because some things are coming up. They're mapping certain areas as a public improvement district to bring in some infrastructure and improvements and those types of things. So again, your best place is to look at the tax jurisdiction on the appraisal district. If you don't see one there, then most likely the property is not subject to it. If you see something and you don't understand, is this an improvement district? For instance, there's one that has, I think it's after Harris County. They have one that's called Inverness Forest Improvement District. You know, when you look at it, you're thinking, hey, there's improvement in there, right? That's the word that you're trying to key on. If you go to this website, you're going to find out it was not formed under Chapter 372. So that's the way that you're going to be able to determine if under the tax jurisdiction in the appraisal district, it has a special district and it's named accordingly or made a name that you're not sure if it is a public improvement district, then you'll go to the website and you're going to look and see, because as it says here, They're either insert either how it was under chapter 372, you have to do that, or 382. Now, 382 districts are only up here in the hill country, inside Bexar County and around Bexar County. So you're not going to look at the word 382 because it's not going to apply to you. But 372 is the chapter that you'll look for. Any questions? Okay. Now, if you look at this, there is no dollar amounts. It talks about the source of where the assessments are coming, right? But there is no dollar amount like we have to have in rates and those type of things for the municipal utility districts on the HAR 400 form. But what it does say is that the sellers will sign and date it, right? And then the undersigned purchaser acknowledges receipt of this notice before the effective date of a binding contract for the purpose of real property. If you were a listing agent and the property was subject to a PID, your seller would never, ever sign a contract until this was signed by the buyer. Same way with your water district notices and your municipal utility district notices. No seller would ever sign a contract without that. So what does that mean? It means that listing agents better do their job, right? Sellers don't know about this. This is our area of expertise. We are the experts when it comes to using our promulgated forms. Now, the problem is that this is an addendum, right? Our water district notices that we use from either the district itself or from HAR, are those addenda?
No, they're notices.
That's right. But this is a notice, and yet they made it an addendum. So one of two things is going to happen. Either they're going to force you to put all of the MUD notices on the contract, and they're going to now call them addendums, or they may change this to a notice rather than an addendum, the same way that we're doing. I don't know which way they're going to go. I know Trex Broker Lawyer Committee is looking at that. My problem is most good title companies, they file these with the deed, and they usually get everybody, to sign them so that they can file them. But, that's not your job. You don't file the deed, the title company does. Your job is to make sure that if it applies to the property, these will all be signed prior to a contract being executed. You can use, even on this addendum, they will allow you to have your sellers contact the district if there is a public improvement district. By statute, they can't charge you more than $10 for the form, and the sellers can use that form the same way they can use those notices in lieu of the HAR 400 form. Any questions?
Yes, I have a question, Marilyn. So if I am the buyer's agent and this form is not completed under documents on the MLS, should I just assume that it is not there, or should I have to check thinking that the listing, the listing agent didn't do their job?
Well, every buyer agent reviews the tax appraisal district information with the buyer on a property they want to put an offer on. Absolutely, every agent does that. So at that point in time, when you're reviewing it, you would look, and if you saw that that property was subject to a municipal utility district or any improvement district that's required to have the addendum, you would at that point tell the other party, I need this completed and please present it to my buyer. So yes, the agent has a duty to review certain things that are public records with their buyer. Any questions? Okay. Now we're going to get to the HOA law changes, okay? Everybody received the HOA reform. Everybody received this form, right? Yes? how HOA laws are changing in Texas. Okay. It is a beautiful piece. It's highly summarized. Texas Realtors provided to us. I'm telling you that if you don't send this out to your sphere, people that you've represented in the past, or even current owners that you know that their properties are subject to an HOA, this is a great document to use to let those parties know my association, my fees went towards this great legislation and law changes, which helped dilute HOAs and POAs, property owners associations, strong reach and grab over the property owner. Our association has been working for years, and every legislation they are able to get a little bit more, but this one was pretty incredible what they were able to do. And you need to let people know that's why you choose a realtor. Your monies went to this, and they did an awesome job. And this is a wonderful document that they used. And I'm going to tell you, most property owners, they're not going to read the legislation. They don't get Texas Realtors, right? So again, this is a great piece to send out to your sphere to let them know. Now here it is. HOA's fees are capped. Subdivision information is $375. If the resale certificate is needed, it will be $75. And if an update to the resale certificate, it is capped at $75. So these are fees that are capped. By law, they can't charge any more. The next thing that is a wonderful source is that TREC is creating a centralized database as effective December 1st. What does that mean? These HOAs are required to file and submit to TREC on their website all of the management certificates, notifications, meetings. It will be there. All the dedicatory instruments will be there, and it will be clear and transparent what fees are charged with the transfer of the property. If the HOA has already filed their requirements, they are given a pass. They don't have to file it with the TREC website until June 1st of 2022. Okay, so you're going to be able to go to the TREC website and find it, or now HOAs are required to maintain websites with management certificates, meeting information, and notifications. Okay, so it's great. For decades, we've tried as agents to get the correct information. We always get the runaround. We get told you can go to the website, and then to do it, you have to pay money, all this kind of stuff. So again, it's really a wonderful benefit that we're going to finally get one place that we can go to, in addition to their own websites that they're required to maintain with all that information. Again, the HOAs are required to file these dedicatory instruments with the county and provide certain contact information on all dedicatory instruments and management certificates. In other words, you're going to be transparent about who you can contact if you need to do that. The other thing is that there has been this overreach for a very long time, where when HOAs get into an issue with fees or fines with the homeowners, they could, and they did, they provided negative credit reporting. Well, now, if the property owners have a protection from negative credit reporting, because when a fine or a fee is in dispute, the HOAs are required to give a detailed report of charges, and they also are now required to offer a payment plan before reporting any delinquencies. So there's a process that they have to go through now to make sure that they don't go straight and provide a negative without having an ability to resolve these disputes and these delinquencies. There's some of it, the language did provide some conflicts of interest within HOA architectural review boards. We had some where the architectural review board, the homeowners sat on these boards, and one homeowner had a dispute with a previous homeowner and was negative and not allowing them, these kinds of things go on all the time. So there's some prevention of a conflict of interest on those type of things. The next one is, it's great. These HOAs thought they were able to go in and interfere and have knowledge of our private agreements between the owner/landlord and tenants. No longer. The only things they can ask for is the tenant's contact information, and they have to know the beginning lease and ending dates. So they are no longer going to be able to say, you give me a copy of your lease. The next one helps protect the homeowner's pocketbook, because now HOAs are required to solicit bids for any contract for services over $50,000. There were several abuses of these very large contracts being awarded without going out and trying to get competitive bids. And bottom line is, this HOA should be protecting the pocketbook of the owner, since all the owners pay for it. There's special assessments in those. So a real good provision as well. The next one is, some HOAs are barred from some prohibiting certain pool safety enclosures on a homeowner's property, the installation of certain security measures on an owner's private property, or certain religious displays. Again, they're able to dilute a little bit of their overreach on those types of elements. The HOA boards are required to provide members with timely notice about meetings. They can't just sneak it up on you or have a meeting and not have provided you proper notice. And the last one is, they improve some of the due process in dispute resolutions with HOAs, and they now provide additional legal avenues when seeking resolution from a dispute with an HOA. Again, this is an awesome document. It's great for you to send out to your sphere or those. And you're going to brag a little bit and say, my fees to my association were able to do this for you, the property owner. I don't know about you, but there's a lot of lobbyists for associations that don't care about anything but the members of their association. We care about all property rights for all owners. And it's very important that we stand back and we take a little time to reflect on this and let our people who might want to use us know that what we're doing to help their property rights.
Marilyn, I have a question. The capped fees, when were those supposed to take effect? Were those supposed to be
September 1st.
9/1?
Yep.
Okay, and what if we see like subdivision information coming in higher than 375? What action can we take?
Well, I think the owner could say, once you've given this to your owner, I'm certain they could say, either you do this or I'm going to notify that you violated the law.
Okay.
There's punishment for them. I don't know about you, but my biggest concern, not so much with big management companies, right? Because they knew this law was coming. They had lobbyists trying to fight it. But it's going to be these privately managed property owners associations and HOAs, you know what I'm saying, that are not managed by a company that does this. Okay, so again, if that is the case, you're going to say, no, the fee is $375 as of September 1st. Would you like me to pursue? Let the sellers know they need to go in there and fight for that.
Marilyn, forgive me for not knowing, but this is coming down from the state of Texas. Is the enforcement of it coming down from the state? I've never been clear on who actually enforces when an HOA has a violation.
Once it's a law, the state is going to enforce their laws.
Okay.
Yep. That's why
Marilyn,
you should be scared.
Okay.
Marilyn, how does this law impact condominium associations?
It
Those
doesn't. Condominiums
doesn't,
are
right?
treated
That's
very
a
differently by law.
different animal, right?
Oh, very different. In fact,
Okay.
a buyer of a property can't even acquire the subdivision information or the condominium association documents and the resale certificate. A seller has to still do that by law.
Okay.
Doesn't affect condominiums. These are HOAs, homeowners associations.
Okay,
Okay, so again, this is a great piece. Use it. We were very fortunate that we were given this document. Now, I'm going to review the addendum for mandatory membership in a property owners association. This is probably, I am sad to say, probably one of the most misused addenda. It's horrible. And agents don't understand it. So if you don't understand it as an agent, I have no idea how you could explain it to your clients. Now, I'm going to reference certain paragraphs here. They're all very important, but I'm going to reference the ones where we've gotten into issues, okay, and what's going on. Paragraph 8 defines subdivision information, and it includes the resale certificate, right? Now, the next paragraph we're going to look at is the fees and deposits for reserves. Whoa, this made a major change that was mandated this year. The form was approved last November. Here's what's happening. If you look at it, it says fees and deposits for reserve, and it says except as provided in paragraphs A and D. Buyer shall pay any and all association fees, deposits, reserves, and other charges. And this is the crazy thing, other charges associated with the transfer of the property not to exceed a certain dollar, and seller shall pay any excess. Well, let me tell you what happens. The language these homeowners associations are using in the documents that they send to the title company have language that many times we would call them prepaids. What are prepaids? Prepaids are what an owner would pay at the property. So some of these associations require the buyer to pay 3 months of prepaids of dues, right? Well, they don't call them prepaids because prepaids are not covered here. They're calling them reserves. Language is important, and this is what is really causing a problem because it's all fees, all charges associated with the transfer of the property, not just a transfer fee. We're talking about all fees and deposits for reserves that are required. Case in point, this also includes capitalization, foundation fees. And we had sellers at closing tables. The listing agents did not listen to me when I talked about this months ago when it became mandatory use. You better know all the charges that are associated with the fees and deposits for reserves. Because case in point, what happened? The seller says, why am I paying this? It was a big fee, right? They said, oh yes, that's the foundation fee. And you have to, he said, I paid it when I bought the property 3 years ago. I had to pay it. So now the seller has to pay it. So here's what I'm going to tell you, and you better listen well. If you haven't done this and your property's not under contract, you're going to get all of the fees and deposits for reserves that are required for a buyer to pay. All of them, and any other charges associated. And the reason for that, if the seller gets this form and it says $150 here, and then the seller finds out they'll have to pay $3,000, the seller's going to say, I don't think so. I'm going to negotiate with the buyer. I'm going to get them to agree to pay to the foundation fee, the capitalization account, whatever is required for negotiations. But don't make the mistake and be a listing agent that's sitting next to your sellers at the closing table and they implode because now they're paying for something that they had paid for as a buyer 3 years before, and you didn't give them the option to negotiate with the buyer. Huge problem. I am going to warn you that be careful about this. We had a title company that actually created an amendment at the closing table because the buyer and seller were in dispute, and the seller says, no, I'm not paying this. And in order to make it work, the title company did an amendment. Well, I don't know about you, but who are the only parties that advise their clients regarding amendments? The agent that
Realtors.
represents them. Yes. Title companies can't practice real estate without a license. So again, be very careful about this listing agent. It really falls all on you. Buyer's agents, they're going to put in a dollar amount. Sometimes they put zero. They make the seller pay for it all. So listing agents, this is really critical that you understand this and that you get this total amount for fees, deposits, and any other charges and reserves. You better get all of them, okay?
Excuse me,
Yes?
excuse me. How do we find out how much these fees will be to actually put that in that blank so we don't do what you just said?
Well, the buyer is gonna present the offer with a dollar amount. Sellers need to know this, and they need to get this information from their HOA.
Okay, okay. Thank you.
So again, this new paragraph, it has caused disaster for sellers. And you know who they blame? The listing agent. And that's true. If you don't know how to use this form, you need to get help. You needed to get clarity before your clients agree to it. So now I'm going to go down to authorization. The reason is A4 many times is done. Do not use the form that the listing agent has pre-filled out, sometimes horribly so, that the seller has actually signed this addendum. You cannot do that. It is a violation of TREC to use a form at the wrong time. This is a contract form, and who presents offers on forms? Only buyers, okay? So if you're a buyer's agent and your buyer agreed to A4, which means they don't have a provision to terminate if they see something that they don't like in the subdivision information. A1 allows them to terminate within so many days of receiving it. A2 does as well. And we'll get to A3 because that's a unique situation that we need to talk about in light of all these law changes and those type of things. But if your buyer chose A4, you better put in writing during your termination option, you need to review all the subdivision information. They won't have a resale certificate at that time, but they will have an ability to review all the subdivision information during the termination option, because they don't have an option to terminate if it's something that they find out they can't comply with. Okay. Now, what happens on D? Here's the scenario. A4 was marked, right? So the seller authorizes the association to release the information, provide the information if requested by the buyer or the title company or any broker to the sale. Now, if buyer does not require the subdivision information or an updated resale certificate, but the title company does, whomever is marked in this box must first pay the title company the cost of obtaining the information prior to the title company ordering it. Well, this has wreaked havoc because we've had buyers who couldn't close on the closing date because they failed to give the payment to the title company in a timely fashion. I've had lots of agents and some brokers who are yakking about title companies not doing their job. Really, it's the agents not doing their job. And what I mean by that, if you were a buyer's agent and the buyer marked this and had A4, well, you're going to hop on it the moment they waive their termination option period. Now, if the title company fails to get it done and they drop the ball, that's a different matter. But the buyer not paying timely to get that information and close on time will be a buyer's agent's biggest headache. Now, if the seller marks this, then the seller has to do the same. And we've had some big top producing agents in your area have title companies always do their bidding. That's how they rule. And the problem was the title company wasn't paid by the seller to get all the information. And the agent wanted to blame the title company for dropping the ball. Well, I don't know about you, but the seller signed this and it says seller shall pay the title company the cost of obtaining the information prior to the title company ordering the information. That change happened because title companies were losing way too much money doing all of this and doing the bidding of all of these listing agents and those types of things, okay? Now I'm gonna give you an example because we're gonna reference back to A3 right now. Here's the scenario. Seller marked D that seller would pay for it. Seller paid for it, acquired it, and all of a sudden, 5 days before closing, the property didn't appraise. Buyer and seller did not agree to a reduction in the sales price to appraised value. Buyer had a right to terminate, they terminated. And now the seller sits with all the documents, right? So now the seller's thinking, I'm going to negotiate A3 with this buyer. I'm going to give them all of the information that I got. And it says buyer does or does not require an updated resale certificate. Well, most sellers are going to say what? Buyer doesn't. But if the title company requires it, they're going to mark buyer under D. It's going to all be on the buyer. And so this is a great provision to use when they mark does not require an updated resale certificate. The seller is not worried about the buyer terminating. They have no provision to terminate when they do not require an updated resale certificate. If they do, then the problem is that the buyer has to give the seller the monies. The seller has to get it and receive it within 10 days after receiving the payment from the buyer. That's a lot of mechanics going on. So again, most sellers are going to want to mark does not require if they've got all the documents and they can give it to the buyer. And then indeed, they're going to mark that if the title company requires something, the buyer is going to pay for it, but they won't have a provision to terminate. I am going to tell you that when I got my license a few decades ago, that we always had the subdivision information prior to an offer, right? You remember that? I think we're there again. And especially in light of the fact that if a seller's got them, they don't have to worry about the delay part of the transaction. On something like that, it's just, it could be a scenario that might work real well. Where we had problems years ago is when we didn't sell the property and the certificate had to be updated again. So some sellers were upset by that, but you know, it was what we had to do. We had to have these documents and provide them to the buyer at time of offer. So again, paragraph A3 is a different option for the seller if they have in their possession all of the subdivision information, right? And then they most likely will say does not require, the buyer doesn't require a resale certificate. And in paragraph D, if the title company requires it, then the buyer will pay for it. The problem we've had lately is the information wasn't acquired either by buyer or seller per authorization. They all marked A4, right? And one party wanted to extend the closing date because they didn't have the documents and they hadn't paid timely, and the title company, they wouldn't even allow them to expedite. And so what happens is the party that was required to pay for this, they'll be in default. There's no provision that says you must extend the closing date if I didn't do what I'm supposed to do for the contract. There's no provision for that. So again, this is a very important document when that property is subject to a mandatory membership in an HOA. And you need to make sure that you use it properly and that the parties are willing to accept what the fees and deposits for reserves and other charges that the seller will have to pay if the buyer doesn't pay for it. Again, this is the point of negotiation. For example, buyer submits this offer and puts $100, right? Seller's going to pay the rest. Seller found out that they were going to have to pay $1,500. Seller sent back an invitation that said, you either pay $750 or I'm not going to agree to your offer. So again, listing agents, you better give your sellers options. You better know those amounts because they have to be on the estimated net sheet. And your failure to do that, if a buyer put 100 and your seller would owe 1,500, it better be sitting over there on that net sheet under what they're required to pay for the transfer of the property and all the fees. Any questions? Just take yourself off of mute. I don't know about you, but we are always dealing with a situation where we have to have so many things going on at the same time so that we can that as agents, we have so many things that go on that we are required to manage and oversight for the parties that we represent and their performance, right? And so again, it's very important that you understand each and every promulgated form and association form, how to use it properly and review it with your clients. Any questions? Okay. Again, just take yourself off of mute. So now we're going to talk just a few more provisions that changed with the legislature. What they did is they allow appraisers now are allowed to conduct what they call an evaluation without complying with the USPAP, which are the Uniform Standards of Practice for Appraisers, okay? And why are they doing that? I can't tell you how many times we don't have an appraisal and we're getting close to the closing date. We've had lots of situations. And so some lenders are probably going to allow an evaluation, just like they did during COVID when they waived the requirement for some appraisals. And those were buyers that were very well liquid and they had lots of assets, and the lender was willing to take the position that we can waive the appraisal, and the buyers agreed to waive that appraisal as well. I am going to tell you, if you've got a cash buyer, do cash buyers need to get an appraisal? Absolutely. And they need to do it during their termination option. And you better have that in writing, because that's your fiduciary duty. They may decide it doesn't matter, I want the property, that's fine. But if you didn't advise them to get an appraisal during their termination option, and believe it or not, if the appraiser was able to conduct an evaluation for a cash transaction, it might go much faster than if they were called to do a full-blown appraisal of a property where there is a lender involved in the transaction. I don't know about you, but cash makes a big difference on timeliness on some of those things. So again, just remember that option. It could be an evaluation that an appraiser gives to a cash buyer.
Is there a place on a form that the buyer can decline officially?
It's only during their termination option. There is no provision for a cash buyer getting an appraiser. None. That's why they have to do it during their termination option. Yeah. So remember during COVID, we had cities weighing in and counties. Were realtors an essential service? Everybody remember that? Wasn't too long ago. And then the governor finally came out and said, no, you are an essential service, right? Well, they codified it now. They made it law that cities and counties cannot limit residential and commercial real estate activities or real estate support services during a state of an emergency. Very, very important process. So now we don't have to worry. I pray to God we don't have another state of emergency, but we don't have to worry about becoming an essential service. Okay. So again, that became law. Now it says real estate support services. What are those? Title companies, appraisers, surveyors, inspectors, all those different types of things. Anything that supports the real estate lenders, anything that supports the real estate industry is considered essential now, which is a great thing. Okay, I'm going to talk about a new provision that everybody's going to say, well, that's no big deal, Marilyn. Oh, really? Well, we've had it become a big deal. There's an automatic provision of a manufacturer's warranty on air conditioning systems to be conveyed with no forms filled out and no fees paid. And here's what happened. We had a buyer who bought a property. The sellers had bought it a couple of years before from a big home builder. There was a 10-year warranty on the air conditioning system. Our buyer contacts the company and says, there's something going, I need something warranted. And they went, nope, you're not the owner of the property. You didn't pay the fee and you didn't fill out the form. So that's the result of this legislation. If now they can't charge you a fee, you don't have to fill it out. They're going to look and determine, is this item under this warranty? And then it will convey to the buyer of the property, which is a good thing. But this brings up something that we all need to pay attention to, and that's about warranties, right? So what we're going to do is we're going to look in our contract, and we're going to look in 7F, which is a big paragraph because it deals with any repairs or treatments that the parties may negotiate during the contract, right? It says that at buyer's election, any transferable warranties received by seller with respect to the repairs and treatments will be transferred to buyer at buyer's expense. So buyer's agents, if this is the case and they negotiated a repair or treatment that had a transferable warranty, buyer's agents, you better tell your buyers in writing, you need to contact them and find out what's involved in transferring it, right? This all needs to be done. Now, what I'm going to tell you is a big thing that comes out after us about warranties is the seller and the seller's disclosure disclosed that they had previous foundation repair, right? And they said in the seller's disclosure, lifetime transferable warranty, right? Buyer, listing agent puts in agent remarks in MLS, lifetime transferable warranty, right? Well, I don't know about you, but if you're a listing agent, you better investigate that because you're going to be in serious trouble. We've had too many of them where the sellers did not have a transferable warranty because the company was no longer in business. A fact that the buyer found out after they closed on the property to try and transfer the warranty. So buyer's agents, if there's any notation about any transferable warranty that the seller is alleging, either on their seller's disclosure or through agent remarks, your buyer is going to determine that during their termination option. Make no mistake. Because then if they don't have it, and the seller alleged that they did, they have a different position to negotiate with the sellers. They may require that the buyers walk away and terminate during their termination option if the parties can't negotiate it properly. But do not make this mistake. Warranties are mentioned in our contracts, but we have warranty issues that come up because one party is alleging they have one when in fact they don't. Okay, so make sure you absolutely cover that. Any questions? Okay, and the last thing I'm going to talk about it again in December because it's better if I present it right before it's going to be mandated by law. It seems to be a little fresher in the context of how it's going to apply. But starting January 1, 2022, landlords will be required to give notice to prospective residential tenants at or before execution of the lease of whether they are aware that the rental dwelling is located in a 100-year floodplain or whether the rental dwelling has flooded at least once in the last 5 years. Now, I'm going to put in a little caveat here. If the listing agent knows that it flooded 7 years ago, it better be disclosed. Any knowledge you have, they need to present. Now, how are they going to do this? Well, I'm on a task force at Texas Realtors, and we are looking at all of the changes that we're going to be making in the residential forms that Texas Realtors provides. One of these will be on the lease itself, right? Prior to a tenant signing, they're going to know this. In our best practices, a landlord is going to provide all of this information in the rental criteria that a prospective applicant signs before they make application. That's the best way to avoid the seller having to reimburse all these fees because you didn't tell me before I made application. If I only knew that it flooded 4 years ago, I would have not made an application. All those elements. So we have best business practices that we follow as a lease listing agent. But we've gotten too many agents who are doing lease listings that really don't understand how dangerous and how litigious it is and risk laden, because we've got landlords who don't know truly how to be landlords. They've just kind of been winging it, and the law is very strict on landlords. It is as well on tenants, but in particular on landlords, and involving fair housing, major warning signs about making sure the transaction is handled perfectly. And that usually falls back on the lease listing agent. If you have a landlord who doesn't know how to be a landlord, you're not going to coach them. You're going to provide information to them. And in December, I will present all those documents that I've presented when I've done the lease listing and representing tenants in regard to fair housing and other documents. We continue to have problems. We continue to have listing agents who think they can charge a pet deposit for an assistance animal. We have lots of things going on. And so again, in December, I will review that in more detail because it's going to be mandated by law January 1 on that type of thing. Any questions? No questions? Okay. Does anyone want to know what we're going to do next month? Yes. Well, next month, we're going to go through the listing agreement. My concern is that we have far too many agents. You have to know something to be a listing agent. I'm not saying you don't have to know something to be a buyer's agent, but that seller is expecting you to be experienced and knowledgeable, as well as a professional. And so what I'm going to do is I'm going to take the listing agreement and I'm going to bring in all these areas that listing agents really make big blunders in not completing the listing agreement properly and not advising what that provision means when they review it with the sellers. So we're going to do that next month. In November, we'll be looking at what TREC has decided, either changing the forms or what they've approved, as well as some other issues regarding contracts and those type of things. All right, good people. Everybody, yes, let's just do it today. You want me to do my listing presentation today? I think you might be getting a listing, which is good. You know, everybody knows there's a saying, you list to last in this business. I can remember when I first became a realtor, they had all these little sayings and I'm thinking, what are they talking about? It was like our own language, right? Well, what that usually meant that if you were a listing agent, your sign was somewhere with your name on it. And I know I had one on a major parkway in Fair Oaks Ranch up here. And any given day, the owners of all the other properties went by my sign about 6 times a day. You know what I'm saying? And they're going to think what? Oh, that agent is everywhere. And when I had just one sign on a strategic property in a high traffic area. It did lead to a lot of listings, but again, that's why they say you list to last. Okay. All right, good people. We'll talk about that next month. Everybody take care and stay safe. Okay. Bye-bye.
Thank
you.
Thanks, Marilyn.
You're welcome.
Marilyn.
Thank you.